Hey everyone, it's Kate Lanigan McGregor. I'm here with Fair Housing and Ethical Practices, Chapter 15. So we will be presenting this to you right behind Unit 3, which is Fair Housing for the General. So you will find that there, okay? But this is talking about the Massachusetts law in particular. Okay, so let's get going. I hope you're enjoying everything. So how to maximize this chapter. I want you to have your book open to the chapter, and I want you to have your recorder from your phone or what available for you. And again, I think it's called, I have here voice command, but I think they changed it to voice memo for the iPhone, and then the Android is called voice recorder. Okay, we're going to follow this timed module, completing each task, including all the quizzes that we have. And the quizzes are not graded. You must complete them in order to move forward. And also there'll be an opportunity for you to ask a question if there's a question that you have that's relating to what we're talking about. You must complete that to move forward. You can pause it, you can review this, or you can just keep on going, but you cannot go forward, like you can't jump forward. All right, you're going to record your progress as you go. So again, whatever I'm talking about, you're going to be talking about also. And what you're going to want to do is make sure that you're giving your audio the benefit of when you're listening to it later, you're going to be getting value from it. Okay, so the value is from saying it, and then the value is from recording it later. Okay, and you're going to visit us on the bottom during the live chat or the questions if you have any questions. Okay, again, remember, we are here for you. We will respond as soon as humanly possible. I think most of you will find it's right away. And the live chat will be you and all of the people who are taking this class with you. So, protected classes. The federal fair housing law prohibits discrimination based on, and I called it fresh corn in the last thing. I'm going to break it down into race, color, religion, sex, including gender identity, national origin, familial status, and disabilities. Okay, so those are the protected classes according to the last one we just went through. Okay. So in Massachusetts, we prohibit the discrimination in housing and real estate activities on the basis of, and I'm going to read these to you, race, color, religion, sex, sexual orientation, including sexual orientation involving minor children, national origin, genetic information, ancestry, marital status, veteran or member of the armed forces, public assistance recipient, age, and handicap, whether it's mental or physical, and gender identity. So the Massachusetts law kind of spells it out into a little bit further detail, okay? So let's dig a little deeper on the protected classes and what's considered protected and how it kind of works, okay? So discrimination against persons who have children is prohibited. The prohibition does not apply to any situation in which the state sanitary code regarding the number of persons who may safely occupy the premises would be violated. Okay, so a lot of times when people do not want the children there, they will say that, there's only one bedroom, that's an office, we don't have room for another bedroom for the children, and there's just not enough room. The provisions of Massachusetts law regarding fair housing practices regulate the activities of all persons who have an ownership interest of any kind in real property and not just real estate licensees. Okay, so when I spoke earlier in the unit before this, I talked about that real estate professionals are not exempt from discrimination. So there's no way that we can discriminate. What this is saying is that for those people who own property, they also cannot do the discrimination, okay? So it's a little bit more specific and a little bit less on exemptions on our state level than on the general level, okay, on the national level. The broad prohibition includes discrimination in offering residential and commercial property for sale or lease, granting mortgage loans, appraising residential real estate, and offering membership or participation in multiple listing or other brokers' organizations. Okay, so we cannot discriminate in any of these possible scenarios. So how does it apply to real estate? Massachusetts anti-discrimination laws apply to the following types of real estate. Multiple dwellings. Okay, so 3 or more independent family units, including housing accommodations, including publicly assisted housing. Okay, so what that means is that you are not allowed to discriminate against somebody who has, say, a Section 8 voucher on their ability to pay. You cannot say, because it's publicly assisted, that you don't want them in your property. Okay. Single-family residences that are directly or through an agent offered to the public for sale, lease, or rental by advertising in a newspaper or otherwise by signs and notices located on the premises or elsewhere, by listing with a broker or other means of public offering. So a lot of times people will kind of try to get their homes rented or their apartments rented. They'll stick a sign in the window, and their goal is that they get to handpick who it is that's living there. And so when a potential tenant comes by and they see that this house is for rent, and then when they call on it and the person says, no, it's not available. And then they go by a week later and that sign is still there, and which means that they haven't rented it. So, the interesting thing is that, the landlords may think that they're being sneaky and cute, and you, if you're kind of inadvertently helping them, may feel like it's going to be okay. But the consumers, the tenants, know. I had an example where I was helping someone try to rent out her house, and we were saying, because she lived there also, and she didn't want the children there. And again, that was by the national. That's one of the ways that, because she has a crazy sleep schedule or whatever, she could, pick kind of a little bit more who's going to live there. So we had a sign there. And so what I would say when the people called was, no, she's going in a different direction or something like that. And so basically one of the people who had tried the week before and still saw the sign there, called me on it and reported it. So, that was a hard lesson to learn. And, so it's tricky. The law in Massachusetts is significant. And then commercial space. So the same thing goes for anything commercial. You have to follow the anti-discrimination laws. So the prohibited activities. The following activities are specifically outlawed in Massachusetts: refusing to rent, lease, sell, or negotiate the sale of any property, or deny or withhold from any person or group of persons such accommodations because of the person's protected class. Okay, so again, we talked about the national exemptions, and what this is saying in Massachusetts is that because they are in a protected class, you cannot discriminate. So this gets a little tricky because sometimes, again, you may not know what it is that's their protected class. And, if it's physical and mental disabilities, you may not readily be able to see what they are. But they're telling you that they are part of this protected class and they have, documentation or whatever. You are not allowed to discriminate. So what happens when, somebody has they're mentally handicapped or whatever because they had drug use or alcohol. And so you don't want them there because you don't know that they will relapse. You don't know what's going to happen with them. So you don't want them there. What our law says is that you can't prohibit them from being considered because of that. Okay, so even though you may feel like it may not make the best, tenant for you, you cannot state that that's how you're making your decision. Okay, and then the next one is discriminating against any person or group in the terms, conditions, or privileges involved with the possession or acquisition of property, or in the furnishings of facilities and services in connection therewith, or because a person possesses a trained guide dog as a result of blindness or hearing impairment. Again, this goes even further now because, guide dogs are not just for blindness and not just for hearing impairment. So you have these dogs that are, they're using them for emotional distress, and they're using them for other purposes, and they have, to actually apply for getting your dog to be a comfort dog is not a hard thing to do. So again, you can't discriminate against pets in that way because they have the paperwork that says that that's what their dog is for. So, again, you may not want pets there. It may be that you've said that you're not going to have pets there. You can't take it, you cannot use that as your reason. So, other prohibited activities. Making an inquiry or record regarding the race, creed, color, national origin, sex, sexual orientation, age, ancestry, or marital status of a person seeking to rent, lease, or buy property, or concerning the fact that the person is a veteran or a member of the armed forces, is blind or hearing impaired, or has other handicaps. Okay, so we have this thing where you can't even say when someone's in a military uniform, you can't say, how do you serve, or thank you for your service, or something like that. That's considered discrimination. That's considered violating their protected class status. So it's kind of tricky on what you can and can't say. And as you and if you are a landlord and you're reading these things and you're saying, this is crazy, this is always how we discriminate, it's just not the law. And right now we have a challenge where rentals are really hard to find, and there's normally many people for that one apartment. And if you are in that position, you want to make sure that you are using something other than their protection in order to say why you are selecting somebody else. Okay. The next one is making false representations regarding the availability of suitable housing, okay, including failing to show all properties listed for sale or rent that are within the requested price range. Okay, so when somebody is asking for something to see or whatever, you can't say to them like, no, this isn't really the right area for you. You have to show them what they're asking for. And I spoke about it, when we're talking about the national, is you also can't pick for them. If you've got two different groups of people coming in and they're looking for the same thing, and you're figuring out what you think would be the best ones for them, that's a discrimination suit waiting to happen. Okay, so what you would do as a professional in real estate would be that you would take all of the things that are available and you would go through them together with that person. Again, those two different parties that are identical in what they're looking for, but may not be identical. One may be Hispanic, one may be, same-sex marriage or whatever. You have got to treat them all the same and let them determine what it is that they want to look for. Okay, if they ask you, like, I want the Asian neighborhood or something, you again should not select a neighborhood that you would call it that. What you would do is you'd say, well, let's go driving around and I'll show you all of the areas and you can tell me the one that feels like, the neighborhood that you might want, and we'll pick from there. Okay, so you do not make the decisions for them. Discrimination is illegal if its purpose is to relieve the owner of the responsibility for removing or covering lead paint. Okay, so we're going to talk about lead paint later, and I used this example already once, in that if you have lead paint in your property and you're a landlord, or actually even a homeowner, and you don't want to de-lead, okay, and so that means that children under the age of 6 cannot live there, well, in the truest sense of the word. So you don't pick those people with children and say, because these other people don't have children, so they're not going to get the lead paint, I don't have to de-lead. You need to make it that cannot be the reason for you to select that. Okay, so your language has to be significantly different than that. Okay. Okay, so I'm going to tell you about a case. It's called Linder versus Boston Fair Housing. Okay, and this was Commission 84, Mass Appeals Court 1125, and this was in 2013. The Massachusetts General Law, Chapter 151B, and the Boston Fair Housing Commission regulation made it illegal for any licensed real estate agent, and this is in quotes, to cause to be made any written or oral inquiry or record concerning any of the protected classes, including national origin or ancestry. Okay, so here's what happened. Paul Linder, a licensed real estate broker, posed a seemingly innocent question to prospective tenants, James and Gladys Stockett. So where are you from? So I might be saying the name wrong. So the Stockels replied, Venezuela. The Stockels went on to find an apartment a month later without further incident. However, the Stockels found the question insulting and upsetting and learned that they feared that they were victims of discrimination, particularly because the Stockels had recently been denied an apartment based on where they were from and had filed an unrelated discrimination lawsuit against a different company. Okay, so, again, here's the hard part. When you're trying to create relationships with these people who are coming in asking you for stuff, a lot of the times your question is where you're from. And you may be thinking they're going to say Georgia. You don't know. It's an icebreaker, back to them, when someone comes in a military outfit, you feel like you can talk about that. But what the laws say is you cannot, okay? And in this particular case, the Linders, not only filed suit about the one that they did not receive, but they also filed suit against the person who they didn't even go with, okay? So they both kind of had the jackpot. Section 806, and it's 42 USC 3606, is discrimination in provision of brokerage services. And here's the quote: "It shall be unlawful to deny any person access to or membership or participation in any multiple listing service, real estate brokers organization, or other service, organization, or facility relating to the business of selling or renting dwellings, or to discriminate against him or her in the terms or conditions of such access, membership, or participation on account of race, color, religion, sex, handicap, familial status, or national origin." Okay, so what this is saying again is that your treatment of people who come into the office has got to be the same. Okay? Mass General Law 151B, subsection 43C, says, "It shall be unlawful practice for any person to deny another person access to, membership, or participation in a multi-listing service, real estate brokers organization, or other service, organization, or facility relating to the business of selling or renting dwellings, or to discriminate against such persons in the terms or conditions of such access, membership, or participation on account of race, color, religion, sex, handicap, sexual orientation," again, which shall not include persons whose sexual orientation involves minor children as the sex object, children, national origin, genetic information, ancestry, or age. Okay, so again, the Massachusetts law is more specific on what they are allowing or not allowing. And as far as the one about the sexual orientation with children, I think what jumps out at me here is that any sexual orientation involving minor children as a sex object is unlawful and would obviously not be a protected class. They have spelled it out for us though. Okay. So exceptions. While an owner is generally required to bear the reasonable expense of modifying structures to make them accessible to handicapped persons, including those with mobility, hearing, or sight impairments, he or she is not required to pay for unreasonable modifications. Okay, so what that means is that, if somebody comes and they, the examples have been, there's 2 apartments available. One of them has, the reasonable modifications would be maybe adjusting some lights, adjusting some countertops. They can take the elevator there or whatever. And then there'd be another one that would need significant renovations or whatever in the same building. that could be something that could be considered unreasonable modifications. If you have an apartment for rent that has no stairs, not has no stairs, has no elevator or no way or no guide to go up, it's not reasonable that you would have to put in an elevator, or if it's not possible to get a rent there, or if you have an old house with skinny stairs, and so there's reasonable modifications are acceptable and are exempt, are not exempt. But if it's unreasonable and it would cause financial duress or duress on the landlord, they, in that case, they are exempt from that. Okay, so other exceptions. A modification or accommodation is considered unreasonable if it imposes an undue hardship on the owner based on such factors as, again, so I just alluded to this, the cost and extent of the modifications or accommodations, modifications affecting or altering the marketability of the housing. So for example, if you needed to, again, change the doors, or change the stairs, or make it so that there's some way that you are making that house less marketable by the alterations. And if it's something that to put it back after the person had moved out would be not possible or not reasonably accommodating, that would also count. Type and size of the property and availability of federal tax deductions. Okay, so again, if you're renting something for $1,000 a month and it's going to cost you $50,000 to make it so you can get that $1,000, you do not have to rent that to them. Okay, you would be exempt from that kind of responsibility. Some more exceptions. Reasonable modifications in making the house accessible for the person impaired in mobility, hearing, and sight include, but are not limited to. One is installing raised numbers, okay? Installing a doorbell that flashes a light, lowering a cabinet. So these are considered reasonable accommodations. Ramping a front entrance of 5 or fewer vertical steps, widening a doorway, and installing a grab bar. Okay, so these are considered reasonable accommodations. No owner is required to bear the cost of modifying more than 10% of the units in their property to make them fully accessible to a person using a wheelchair. No additional rent or charge for the handicapped accessible housing may be imposed. Okay, so what this is saying is if you owned an apartment building and you had and it had 10 units, and you already had 2 people who were handicapped that were using it, and then a third person came in and you needed to make more accommodations, this is saying that you would not need to do that, and you would have the ability to deny that person the rent there, the opportunity to rent there. Okay, so blockbusting. Blockbusting in Massachusetts is prohibited. Okay, and blockbusting is the act of encouraging people to sell or rent their homes by claiming that the entry of a protected class of people into that area will have some sort of negative impact on property values. So again, what this means is that, there was a time that they were trying to scare people out of their houses and move them away at below market value. And one of the things that they were saying was instilling fear in them that the people who would be moving in were, in part of a protected class, and that they would be bringing down the values of their property. So that's prohibited now. That's actually, as I said, that's the federal law as well as the state law. Aren't these fun? Okay, redlining. Redlining is the practice of refusing to make mortgage loans or issue insurance policies in specific areas for reasons other than the economic qualifications of the applicants. Again, that's that red magic marker right down the map of who it is that you don't want to work with and who you feel is a higher risk by virtue of, their protected class, or, where they're living, and, what neighborhood that may be. Steering. Massachusetts law prohibits the practice of steering. And again, steering is the channeling of home seekers to particular neighborhoods. It also discourages potential buyers from considering certain areas. Okay, so I talked about this a little bit. I'm just going to say clearly the 2 opportunities that this comes into play. One is if somebody comes into your office and, they are Asian, and you think that they might want to go live near Chinatown. So that's where you show them. Okay, that is steering. The other is that if someone comes in that is not one of those protected classes and says, hey, I'd like to go look at, 123 Main Street. And you say, ooh, you don't want to go there. That's not a good neighborhood for you. So you can steer either direction by virtue of how it is that you're describing it. Okay. So, the subtle ways that we see this, which is again is not really discrimination as much as it's not fair housing, is if someone says, only show me the good neighborhoods, or, where is it that, that I should go or live or whatever. And you don't want to make that determination for them. As I said, you show them everything that fits their criteria as far as the kind of house they're looking for, the number of bedrooms they need, the amount of money that they have to spend, and you walk it through with them. You go in a car, you show them neighborhoods. Okay, you don't determine the neighborhood for them. Okay, so Mass General Law 151B, subsection 7, requires that a notice stating that the agency or office complies with the provisions of the Massachusetts law against discrimination must be conspicuously displayed in every real estate agency and rental office. The display may also include a summary of unlawful activities. Okay, and I will attach to the notes a copy of what we used that goes into every office. Any real estate agency or rental office that fails to comply with this requirement is subject to a fine of up to $100, and for the subsequent violation occurring within 60 days of the first, up to $1,000. Okay, so when the testers come and they come into your building and they see that you don't have this up, and they cite you on it, and then you say, well, whatever, I'm not doing it. $100 is not that big of a deal. And they come back within the 60-day period and you still haven't put it up, then you have up to $1,000 fine. And that's a bigger bite. Okay, so enforcement. Again, because many of the Massachusetts law provisions against discrimination are similar to those of the Federal Fair Housing Act of 1968, the Massachusetts regulations have been ruled substantially equivalent to the federal law. So for this reason, all fair housing complaints in Massachusetts are referred to and investigated by the Massachusetts Commission Against Discrimination, or MCAD. It's an agency that reports directly to the governor's office. And again, those stories that I told you about with that friend I was trying to help, that's where we got reported to. Okay. All right. So what are we going to do beyond this chapter? There's a lot of good information in here. Again, there's a lot of memorization here. Some of the things that you want to think about are, what are the laws? What are the exemptions? And how does it relate to my job? Okay, so how it relates to your job, I gave you that information because I think it adds context for you to understand why it's like that. However, that's probably not going to be like that on the test. They do, however, again, in the 40 questions, they always ask about these things. So you're going to read your key point review in the chapter, and you're going to read the quizzes and answers, and are you right or wrong and why. Okay, so the quiz bank is for the general, so this is not for the state. You will have state questions that will be available to you in a training module, as well as in the back of your book, okay? So take your quizzes, recording the thoughts as you do, okay? So the same thing that we talked about before. What did you answer? Was it right? Was it wrong? Why did you answer it the way you did? And what was the reason for it? Again, circle the loop of your train of thought so that when it comes time for you to review it later, when you're listening to it while driving your car, it all makes sense, okay? And then you can send us your recordings for your accountability. Again, these do not count for your hours, but it kind of lets us know what you're doing and helps us get you ready for your preparation. And then test us or email us with any questions. You also have right below you in this training module the live chat, which we answer right away, and that's also where your other team members that are taking this class with you are in that same chat box, chat line, and you can also email us where it says questions. We put on the website, agentrising.com, the frequently asked questions, and that might be a place to look if you want to check there first, if you don't want to talk to us. All right, again, we are here to help you rise to the top. I am Kate Lanigan McGregor, and I'm working with Dawn Devlin, who is another instructor, and Marie Greeny, who is the Dean of Students. And, I always say that Marie is the get it done girl. I would start with her almost always. Thanks so much. Make it a bold day.